What's your blood?
My Lord, the microphone, I don't know, seems to be far. No, my Lord, because you did not donate it to him. I would pray that you kept my minutes intact. Thank you, my Lord. My Lord, I'll be brief. Number one, the law. We brought this application under, among others, Section 17 of the Judicature Act, in particular subsection 2, where this court is enjoined, 17.2, where this honorable court is enjoined with inherent powers. A, to prevent abuse of the process of this court, and we insist these separate trials are an abuse of court process. I am fortified by the submissions of my learned friend, Lord Mayor, in terms of the juxtapositions of dates, events, and places. Number two, powers to make orders for expeditious trial. And don't forget, A has a reason of curtailing delays. Number three, to ensure substantive justice being administered without undue regard to technicalities, which is basically reproduction of Article 126(2)(c) of the Constitution. I do not need to restate the powers of this Honourable Court under Section 33 of the Judicature Act, because this court is the custodian of those laws. My Lord, the principles have been clearly elucidated, but let me also find fortification in the decision of the Honourable Justice Mubiru Stephen. In the case of Aliobe Joseph, A-L-I-O-B-E, Aliobe Joseph, and two others versus Uganda, which I have submitted to your Lordship. Pages 1 to 2 are highlighted, and he emphasizes the reason for consolidation. First, he notes that the Trial and Indictments Act is silent on this subject of consolidation. Perhaps that's why my colleagues who have practiced criminal law long enough were finding it alien. But he gave the principles, and of course after considering a series of other cases that enrich our jurisprudence. In particular, he addressed his mind to Section 17(2) of the Judicature Act. That is the first principle. One, avoid delays and therefore ensure an expeditious hearing and disposal of cases. The second is to avoid a miscarriage of justice. Miscarriage of justice, how? That you're asking the accused persons to defend themselves separately on allegations arising out of a similar set of circumstances. My Lord, the other reason for consolidation again is yes, jurisdiction. It is the jurisdiction of the High Court, again under this section. And we are in the same jurisdiction of the High Court. Never mind that there could be special procedural provisions which talk about the ICD in particular. But constitutionally, we're talking about the High Court. And indeed, it was not our choice of where to take this case, but the prosecution's case. My Lord, the other emphasis is placed on the class of cases. If you go back to conventional criminal law, you'll find these are offenses, one, against the state, and offenses which involve violence. And as my learned friend submitted, the motive of the so-called terrorism, which is now a political offense, is murder to intimidate. So you're going to find that the serialization of activities as alleged in the charge sheets will connect the cases. But you may also find pleasure, my lord, in looking at the way they coached their charge sheets. You will find that in some instances they have been specific on dates, on the 2nd day of August. But in other instances they will simply say, between the month of January and August, and they say, in some cases now they have lumped them in between. And of course, between the month of January and August necessarily includes 2nd August. Now, in other cases, you're going to find on this date, that is the 2nd. I would invite your lordship to look at Annexure A, and I prefer using the Annexure of the state, that is the respondent. Look at Annexure B, and once you examine those ones, they will lead you to the same conclusion that these were serialized events, which are being talked about in those authorities that we have submitted. You'll also find, and I invite you to find pleasure, in looking at the case of Uganda versus Ojuya Santo. My lord, in Ojuya Santo, and Uganda versus Ojuya Santo and 4 others, criminal case number 12 of 2017. In particular, to be specific, pages 6 to 7. Again, you're going to find that these are the same principles. For this proviso, I read paragraph 10. To apply, there must be a common factual origin. Now, the common factual origin is Masaka, Rakai, and Luengo. The other factual origin is the alleged participants. You're going to find they are interconnected. There must be a common factual origin, connection or nexus between the offenses. There is a connection in terms of critical connection between attempted murder and as you look at these offenses. But we are more fortified by the fact that the purported latter offenses were actually charged last, when they already had the purported offenses that were committed first. And the court continues, and it must be convenient in all circumstances to try the offenses together, even for court's convenience, rather than separately. See Lodro versus Metropolitan Police Commissioner, and you'll read for yourself, my lord. My lord, sometimes the court says failure to try related charges together would constitute a harassment, and I emphasize harassment, or unduly consume the time or resources of the parties. And here for the parties, I'm more concerned about the applicants. Because the state has the budget. These people have never prepared a budget for trial. And now they're being subjected to defend in Kampala and in Masaka, even when matters are related. The trial court should encourage joinder of charges for trial unless it determines the joinder is not in the best interests of justice. And that takes me to the affidavit of Mr. Malandi friend, Mr. Thomas Jatiko. Mr. Thomas Jatiko, who is not on record as having participated in this case in this court, claims that he's one of the prosecutors handling these criminal cases. And that is not true. You will examine your record. He's nowhere. And the prosecution is not in the DPP's office. Prosecution is in court. My lord, Mr. Jatiko says that in paragraph 9, that the accused persons were released on bail. That one is also not true. They were granted bail, but they were not released. And the affidavit in support of the application explains it all. Indeed, my learned friend has made submissions at length on this. Mr. Jatiko makes reference to a constitutional petition by Mr. Nebakiriza. That is also alien to this court. It cannot be a reason to refuse consolidation. It's not even anywhere in the principles. Secondly, my lord, he claims that in paragraph 14, that the application or that these cases raise different questions of law. Because one murder is in Luengo, the other one is in Rakai, they raise different questions of law? Certainly not. Murder is murder and only charged in one section of the penal code. The questions of law are basically not even the same, but one question of law as to whether someone killed and the ingredients do not change. That facts are different. Naturally, for every count, the facts will be different. That today you killed from Luengo, the other day you killed from Rakai. This day you killed, this day you were just persecuted. Facts will always differ. But once the series are interconnected and intertwined, then this is a proper case for consolidation. My lord, he addresses delay. The delay is on their part. And indeed, you must have noticed that they do not want the matter to proceed. They keep saying, no, we have a PO. Then the next thing they say, there is Nebakiriza, who is not in this court. But the submission on delay is that actually it has been created or is likely to be created by separate trials and 2 by the state. Since August 2021 to date, it's a year. And who has stopped them from bringing evidence and prosecuting? My lord, there is a question.
It is now half midday. I give you the 3 minutes which you're committed to.
I appreciate, my lord. My lord, thank you very much. Now, let's go to the miscarriage of justice that Mr. Jatiko talks about, and he also talks about the prejudice. How prejudicial is it consolidating 2 cases, hearing them at once? The witnesses are known by the state. In a number of them, we do not know them. They have them. The evidence, they have stated before this honorable court, they have finished. They committed the accused persons to court and said they are ready. So the best thing, my lord, is to, 1, consolidate and guide on how to proceed. What happens, if I may be of assistance to them, to my colleagues for the state, and with immense respect, of course, is that once a matter is consolidated, it becomes one. But the counts remain counts in that final charge sheet. And they are duty bound to bring evidence on both of them. Indeed, we have the same prosecutor, more or less the same parties, and the same lawyers. We will not find difficulty, therefore, in defending the same if consolidated. My lord, considering the conduct of the state, that the accused have been granted bail before and they have frustrated the same, they are incarcerated. If they were out, 1, enjoying their right to freedom, 2, representing their constituencies, we would afford to give all the time that the state needs. But considering that their freedoms are curtailed, they are not representing their people. The other co-accused, for whom I do not certainly speak, are young people who have a life to live. The best interest would be to consolidate and charge them once and for all. The country will need to know, are they guilty or not? So, my lord, there are other authorities I would invite court to consider, which we have not been able, and in 1 minute, which we have not been able to print because of the nature, but we'll provide the link if you permit within the course of the day. There is this case of Adela.
How will your colleagues attempt to fix? How will they
It will be about principles of law, my lord, and that's what we are trained to do. It is just basically about principles. I'll provide the citation. The citation I have. I'll also provide the link, and that's what I was talking about for purposes of court. Thank you, my lord. My lord, the case of Adela versus Adela J. Canons. Adela is A-D-E-L-A J. Canons is C-A-N-O-S versus E-L Peralta. Peralta is P-E-R-A-L-T-A. It's a Filipinos case. And it is, the citation is G-R Canons Peralta, P-E-R-A-L-T-A. It is GR number L-38352. The Court of Philippines.
Mr. Segona, you have one minute.
Guide me, my lord. On 1 minute, I will be sitting down. Thank you. Thank you, my lord. That a joint trial is permissible where the actions arise from the same act. Now, in this case, murder. Event where the actions arise from the same act, and in this case, murder. Event or transactions or involve same or like issues. And my lord, you don't need to go beyond those four corners. Thank you, my lord, and we invite you to find in favor of the applicants.
Please, as well, Sunny, what of you? We also have 30 minutes, which is now 4:45.
My lord, we seek a standover of about 40 minutes.
40?
Yes, my lord, or 30. The reason for that, my lord, is that our brothers have given us these authorities that we need to go through because they didn't disclose them before. So we need to go through them so that we are able to actually defend the respondent. We so pray.
My lord, we concede, we have no problem. Maybe they will come up with the concession after we do the authority.
Please take us to the lunch hour. So are you going to have lunch now? We have finished. So it's now 11:35. The 30 minutes we're talking about is 5 minutes after 1.
Yes, because 2 p.m. and another.
Maybe your authorities are also not quite detailed on the 30 minutes, which the
30 minutes.
spirit of fairness, I have to let them have the 30 minutes. But that means you come back here at 1, at 1.
Yeah, we are happy to come back.
1:15, 1:15.
Yeah, it's okay.
Okay. I'll bring you at 1:15.
Most welcome. Please, what is still going on?
So this matter is scheduled at 1:15.
Also blessed.
Yeah, at 1:15 to hear from the respondent.
That's